Number 26159, MP Corporation versus Redbridge, Bedford, LLC.
May it please the court. Good afternoon, Your Honors. I'd like to reserve 2 minutes.
2 minutes, sir, you may have that.
And I'd like to say what a privilege it is again to appear before this body. Obviously, this case comes to this court in a very unusual way. It's a 1 in 5 chance that when you have a decision below against you, that all 4 justices decide to grant leave to appeal to the Court of Appeals. It happens in less than 20% of the cases, in fact. And we think, I'm with Merrill Winnick, who was on brief and argued the case below, we believe that the court below missed the point.
Well, let me ask you this. Why, first of all, could the parties have negotiated an agreement that didn't have a cure period at all?
I would say no under Yellowstone. I would say they have, if they had, if
Well,
they,
the legislature
waiving,
has written a cure period in for residential leases, right?
Correct.
They haven't done that for
only in New York City
commercial leases.
for commercials. Only in New York City. It's the only place where they have written such a thing in. Now, this is
So that
obviously,
means that in the vast majority of places, there's no requirement of a cure period, right?
well, there's a requirement that you cure, but there's no requirement that there be a stay in this, in a
Okay,
commercial.
and by the same token, the legislature has, in a whole variety of contexts in the landlord-tenant realm, indicated when parties cannot waive, when tenants in particular
Well, tenants.
can't waive certain rights, correct?
Correct.
Okay. One more question in this line of questioning, which is, so why do we allow parties in general to waive judicial review completely in favor of arbitration?
Well, that's not here.
Well,
That-
I know it's not here, but I'm asking you, you're making a public policy argument. You're saying that they have to have this right to seek a declaratory judgment in court, otherwise it's against public policy. I'm saying that if we have allowed parties to forego all, and I'm not saying that we should allow that here, but because I think our case law says that there has to be some access to the courts in this context. But if we allow that in other contexts, how can we say that it is against public policy ever to allow a landlord and a tenant to agree to waive that right?
Because you yourself, Your Honor, Judge Stein, you just said it, hit the nail on the head. If this had been sent to AAA, arbitration, and that clause was in this contract, we would not be here today.
Because the point being that you have another forum in which to adjudicate the respective responsibility.
Absolutely correct.
But you have that forum here. You have a summary proceeding, which is the forum that was explicitly chosen. You have the right to sue for a breach of contract. You have the right to sue under tort.
The tenant can't commence a summary proceeding,
Right.
correct?
We cannot commence a summary proceeding at all.
I understand that, but there is a forum for which the tenant can present when asked to leave the premises, can say, well, wait a minute, I haven't done anything wrong.
But they can't,
Or,
there really isn't one. That's the point here.
Maybe
Well,
it would be
if the
helpful.
tenant is served with a notice to cure, right, and he cures the default, is there anything in the lease that prevents him from suing for breach of contract and collecting damages?
Yes, Your Honor.
What would that be?
That would be, I believe, Clause 67, I believe Clause 67F of this contract. This contract, excuse me, 67D of this contract prevents us from going against the landlord. This lease is one of the few leases I can ever say that completely avoids judicial review.
Counsel, let's try it a different way, because I think the dissent tried to do this, and maybe you can help us here.
We agree with this.
Maybe you can help us here. What is it that would not happen if we upheld, right? What is it that the tenant cannot do if we upheld this blanket prohibition on?
Everything.
I know, but I appreciate that. Walk through that, because I think that's the tension.
Let's start with what landlord and tenant court commercial park can do. They can't help us stay. They can't.
When you say they can't, you mean they don't have the equitable powers?
Correct.
And you've abandoned those equitable powers by the nature of the contract.
Absolutely correct, Your Honor. And
So you have to cure or risk the summary proceeding when you're in a defensive posture.
correct. And we have.
What do you lose? That's the question. What does the tenant lose in that way of handling the tenant's concerns?
Because we have because if we can't have our remedy in housing court,
Yeah.
landlord and tenant court,
Yeah.
I'm using an old term, we have a situation where we can't bring on a declaratory judgment in Supreme.
Right.
And the civil court can't give us the relief we need.
But wouldn't one of two things happen? Either the landlord brings you into housing court, and then you can litigate your rights, or the landlord doesn't, in which case you remain in possession of the property and carry on your business. So I don't
Your
know
Honor,
what you've lost.
In the first proceeding, this is one of several, by the way. In the first proceeding, the landlord said he wouldn't enforce Clause 67H, and now we have a proceeding to enforce 67H.
Let me ask you a question about your public policy argument. As I understand it, the Yellowstone, the case that established the Yellowstone injunction was in, give me your attention for a second, was in
Okay.
1968, right?
Correct.
So it's the 50th anniversary, and it's been the common law of the state of New York for the past 50 years that you can get an injunction to cure a breach. Is that correct?
Correct.
All right. So how long have you been practicing real estate law?
Not very long, Your Honor, 5, 6 years.
Well, longer than I have, I'll tell you that, because you seem to know a lot more about it than I do.
Everyone-
But, yeah.
Everybody
but,
would recognize me on a different topic.
What will be the effect, what is your opinion on what will be the effect of this court's decision if this court says that the freedom of contract, or if this court says that this provision stands and that it's not subject to any public policy constraint?
Expansion.
What do you mean by expansion?
Expansion. It's going to expand into mom and pop stores. It's going to
Well,
expand.
let me ask this.
And
Is it-
eventually, there'll be pressure on the legislature.
Stay with me. Stay with me on this. Is there any practicing lawyer that would not include this provision if you're representing the landlord?
I've seen other contracts that do not include this
All right.
provision.
From this point
On
forward,
commercial.
would there be any lawyers that do that?
I would, this court, if it finds that you can avail yourself of this clause, ignoring Article 1 of the state constitution and 4 and 14 of the U.S. Constitution, and avoid all due process
Let's
rights.
just stay on Yellowstone, all right? Let's
Okay,
not
if
go
you
on.
want to stay there, fine, but the public policy argument is very simple. If you allow this to happen, it will increase, it'll become standard practice in New York, and that's why this decision has such a monumental impact.
I think the point that Judge Fahey is trying to draw out of you is whether or not, if you uphold this, it essentially guts the Yellowstone
Yes.
remedy and eliminates it.
Well, yes, it eliminates as a remedy.
Counsel, if I could ask, I'm sorry.
And from a slightly different approach on public policy, in a hypothetical situation where you have a tax escalation clause, so let's take it out of this particular case, and the parties don't agree, and then you have this clause, right, in the contract. Is there a way for the tenant to promote the fulfillment of the contract by both sides without first breaching?
I don't know how. I don't know how you can do it.
So there would be no other remedy other than you forcing the tenant into a breach?
Correct.
Counsel, when I think of public policy where we say, oh, you can't contract to do this, obviously the thing that comes to mind for me is statute of limitations, right? And in those cases, we've said there's a societal interest in the repose of human affairs, and we use rhetoric to that, of that kind. What analogous public policy interest has a court found in a situation like this? I mean, here, there may be two commercial parties that think this is a great deal for us, 10 years, I want it. And we say, you know what, society has an interest here too, and we're going to put a stop to that. Here, seems to me you're arguing this is a bad deal for certain tenants, particularly smaller commercial tenants. It seems to me that isn't the type of public policy or issue we've looked to in undoing commercial contracts.
We're not undoing the contract in its entirety, number one. Excuse me, right? And secondly, an escalator clause for insurance, the insurance bill is what it is. In this case, there was one violation that we moved in on the other.
That's a bad scenario here, we can say. Let's assume you're right, and these facts, that's a bad scenario, but we don't make a public policy determination. I mean, this is such an important issue that, as you point out in your brief, you can raise this for the first time in the appellate division. It's such an important issue. Limited times you can do that. So what is the overriding societal interest in undoing this type of agreement between contracting commercial parties? As a general matter.
As a general matter, it's evading review of the courts entirely.
So can
You're
you give me
taking
an analogy?
yourself, the Court of Appeals,
Not entirely, just that the tenant can't be the first one to
Right.
go into housing court. There's still an avenue.
we still can't counterclaim. That's in the contract. We have no right to counterclaim. So even if we were able to get into housing court, we couldn't do anything.
So is it possible that, I'm having a little bit of difficulty distinguishing between your argument and an unconscionability argument. And I do think there are two different things. I think that that arguably, that one could make an argument, maybe in this case, maybe not in this case, maybe just in the mom and pop case, the bodega, whatever, but that this particular contract is unconscionable, okay? And we have a long line of cases that do that, but that's different from saying that as a matter of public policy, there can never be a situation in which two sophisticated, knowledgeable, equal bargaining power parties could ever agree to this.
Well, number one, in commercial leases, I don't think there are equal bargaining parties in most of the cases. Because you want the space, this is your space. In this particular case, the tenant took the risk of an emerging neighborhood.
But
He
you
took
see,
the
you're
risk.
talking about this particular case again, and that's my point. That maybe you have an argument, I don't know that I agree with it, that in this particular case, it's an unconscionable agreement because of all these factors, but that still doesn't say to me.
It still should
that
be
it-
against public policy to give us no remedy, no arbitration clause, nothing that the court can review. And that's the crux of the case. This case, under this contract, avoids court review in every instance. We cannot counterclaim, we can't bring declaratory judgment, we can't get relief from the courts that we can go to.
But you can't, if they try to evict you because they say you've breached the lease, and you demonstrate that you haven't breached the lease, there is judicial review of that, and if you're right, then they can't evict you.
Well, if they start,
So that's not an
they've already
absence.
started that action.
That's not an
But how am I going to do it without putting forward a counterclaim? Am I have to get
No, your
cute and
defense
put it
is,
in?
your defense is, I haven't breached the lease.
Am I going to have to get cute to avoid the $45 motion and put it in as affirmative defense?
Thank you, counsel. Counsel?
Good afternoon. May it please the court. My name is Jonathan Lupkin, and I represent the respondent here. This case, in our assessment, is fairly straightforward. It
So
goes.
isn't the problem, though, in part with this blanket waiver, that it puts the tenant in the position of having to cure, even though they think they have no responsibility to do so, or, I don't know what, if they don't think there is actually anything to cure or breach?
Well, that's.
How is that in furtherance of public policy, to force a party to have to make that kind of choice?
Well, first of all, it presupposes, Your Honor, that there is an obligation to give a cure period. And there are at least two cases that we cited in our brief. The Queens case, and I'll get you the name of the other one in a moment. Bear with me for just a second. The Victory Taxi Garage case. In both of those cases, those were commercial leases in which there was no cure period for certain breaches. And so if you accept the premise that a cure period is not required, it doesn't take that much of a stretch to assume that you don't need to get a stay from a cure period. I don't know whether that answers your question, Your Honor.
It doesn't, because they've got the cure period here, so I'd really like you to kind of get to that question.
Of
Got
course.
the cure period. The point of that Yellowstone injunction, the way the system has worked until now, is that they go in, they seek injunctive relief. We're at status quo so that a court can decide their rights. And if the landlord is correct, they've got an opportunity to cure, or they're going to have to leave if they don't.
I don't necessarily agree with that for the following reason. First of all, they have the right to adjudicate the propriety of the notice to cure and the breaches in the landlord-tenant court. That's what's specifically contemplated not only by the leases here, but also by the RPAPL in providing for
How would they
summary.
do that?
How would what?
Walk me through how they do
Oh,
that.
sure. There would be a notice to cure served. They would either cure or not cure.
Correct.
And then the landlord would then have to bring on a summary proceeding and saying,
And that
you are
was
in
my
breach.
point. That was my point. They are going to have to choose whether or not to breach, because they may not believe they have to cure anything.
Well, then that's
And then they're in a defensive posture as opposed to seeking a court explicitly clarifying what their rights are.
But they're only in breach once the landlord-tenant court concludes they're in breach. If I'm the landlord and I say to you, you are in
But they're in
breach.
limbo, right? If you don't start the summary judgment proceeding, they're in limbo, correct?
There's an
And if you do,
uncertainty,
then they're in a
yes.
defensive posture. They don't have all the defenses they would otherwise have, so.
Well, they do have all of the other defenses. The only thing they don't have is the right to avail themselves of the affirmative procedural mechanism that is a declaratory judgment.
So that's the point. The way you've structured this is that the tenant can only operate from a defensive posture. And so going back to the tax escalation hypothetical, they either pay all the tax and give in, or they breach by not paying the tax.
With respect, Judge, I don't agree with that. In the scenario you just posited with the tax escalation clause, they could do as one typically does in federal court if there's a challenge to a tax. They pay the tax and then they challenge it later. There's absolutely nothing in this clause 67H that prevents an after-the-fact adjudication as to whether or not the payment of those taxes were appropriate or not appropriate.
Counsel, have you ever seen a clause like this in another contract? Is this the first one you've ever seen?
No, I've seen them in a couple of other contexts, but I've
Because I
not seen
keep
them
hearing
frequently.
that up till now, everyone could go into court, but it may well be that up till now, no one's tried to do this because they made a commercial agreement not to, right?
Well, that's also true. In my view, respectfully, what this does is it changes
Because
the...
one might read the existing law not to permit it.
I looked at the cases, and I have not seen any case law cited in either the opening brief or in the reply brief that would stand for the proposition that an entitlement to a discretionary declaratory judgment violates, that the absence of a right to a
Seems
declaratory
that
judgment.
we're dealing with cases that we don't know exist, and we're speculating, really, if they do or not in this discussion. What I'm curious about is, I wanted your take on the same question I asked opposing counsel, which is on the Yellowstone injunction question itself. As I said before, the case that established it has been in effect for 50 years in New York. It's intricately woven into the commercial practice, particularly in the city of New York. If we rule in your favor, wouldn't that represent, number one, an overturning of the case that established the Yellowstone injunction from all new contracts forward, and secondly, a radical departure from our own jurisprudence?
Let me address the first point first.
There's two parts, and the reason the second part's important, and I just wanted to get it on the record, is because, of course, there's a different standard than a declaratory judgment standard that applies to a Yellowstone injunction, so we're dealing with something slightly different here than a DJ. Go ahead.
Yes, I understand that. First of all, it would not be overturning Yellowstone for the
Really?
following reason.
Wouldn't you as a commercial litigator be committing malpractice if you drew up a contract that if we upheld this provision and didn't include this provision?
I think it would depend on the circumstances of the bargain.
I see. Okay,
So
go ahead, Counselor.
to go a little bit further on that,
Yeah.
if I may,
Yeah.
what I began to say was that this really changes what the playing field looks like. Fundamentally, the tenant will have whatever leverage the tenant has to urge whatever it is that the tenant wants to urge, and the landlord will have the similar leverage to do or not do as he sees fit. The only thing that will change is the board on which they're playing the chess game. It will change the dynamic. It might mean that
By that,
from
I
a
assume
tenant
you mean
standpoint,
the powers of the court that they're before, in front of a different court.
yes, but to go back to the concept of the game, the chess game that we're talking about here, if a landlord insists upon this clause, then the tenant is certainly within his rights to insist upon a much greater concession. So, for example, I can imagine a scenario where a tenant says, okay, you want a waiver of Yellowstone injunctions? I want 1.5 years of free rent. I don't know that anyone on the court would say that that's untoward, improper, or otherwise. And furthermore, with respect to the importance of this concept, the legislature, Judge Stein, you pointed this out, the legislature specifically contemplated the importance in the context of residential leases by, in effect, tacking on a statutory cure period.
So you would agree that a small commercial business owner might have a very different degree of leverage than a big, sophisticated, corporation, whatever. So does that mean that in determining whether one of these provisions would be acceptable would depend on the circumstances of each case? Is that what you're saying?
What I'm saying is that in this, we're here on this particular
No,
case.
I know, but we need to think about whatever we decide here, what the impact is going to be on many, many, many other cases. So
I don't think that the answer would be any different with respect to any number of other clauses that might appear in a commercial lease. If there's
I guess what, maybe I'm misunderstanding the question, but the question that I have, and I think it's the same, is let's say it's not a big corporation. It's, Joe Smith wants to open a hair salon and signs a commercial lease that has this clause with a big, corporate management company or real estate corporation.
Well, I'm sorry, go ahead.
Is it still enforceable?
I think that the answer to that is yes, because if the answer is no, then every provision of every commercial lease would be scrutinized. And the statute is very clear that there are only certain enumerated statutory rights that may not be given up.
So
A Yellowstone
really
injunction is not one of them, except in the context of a residential lease. And
So
there, the
really,
legislature saw
it's
fit to
where-
impose one.
It's the source of the public policy argument. Is that what you're saying? In other words, if it was a constitutional source or a statutory source for the public policy argument, then that's on stronger ground in your mind than some other source.
I do believe that that's correct, Your Honor.
So that's a fair argument. I don't think that's an unfair argument. In my mind, though, I say to myself, why isn't the common law a sufficient source of a public policy argument, particularly something as well established as this over a long period of time?
Well, all that would change is that the terms of the lease would change. Maybe some leases would have this provision in it, and maybe others would not. It depends on how the parties bargain. But
isn't part
go
of the
ahead.
public policy argument, at least as I understood it from the dissent, the potential to destabilize these contracts? Because there's a lack of certainty, and again,
Well, let me-
tenants are put in the position of having to breach. And isn't that part of the public policy that we have to take into consideration?
As I understood the appellant's argument, the question was being held in an uncertain state of limbo, and my response to that would be as follows. Under no circumstances, even with this clause, 67H, would a breach be sitting out there indefinitely. At the outer boundaries, it would be metered by the 6-year statute of limitations for breach of contract. But
That's a long time
but
to run a shop that you can't get loans, you're afraid to order produce or product because of having bills accumulate and you being stuck with those contracts?
True enough, but the reality is that there is a way to negotiate around that uncertainty, and one could engraft onto this clause a requirement that any breach that is identified in a notice to cure would have to be adjudicated in the landlord-tenant court within 1 year. There's certainly no prohibition on shortening the statute of limitations. There is a prohibition on elongating it, and I think that the circumstances of this case illustrate in a very clear fashion what is permitted to happen if the parties don't want it to happen, and that is to allow a tenancy to continue for 1,500 days when it was clear in the lease, as expressed by both parties, that the resolution of these disputes was supposed to be made in the landlord-tenant court. Unless the court has any other questions, I will rest on my papers, and I thank you very much.
Thank you, counsel. Counsel?
May it please the court briefly to finish. Yes, this bill, this contract does change the playing field dramatically. And Judge Rivera is 100% correct. With these actions going on, you can't get credit, you can't buy material, you can't buy produce, you can't do almost anything. We're out of business with these type of actions. Summary proceedings can't revive a lease, grant an injunction, toll a cure, avoid technical breaches, direct the landlord to complete alterations that they promised to work on, grant discovery of issues. You have no discovery.
If tenants decided that, they're not going to agree to these provisions unless there's some consideration, some valuable consideration coming back the other way, or there's some limitation on it or whatever, then the owners, they won't be able to find anybody to fill their properties, will they?
That's not true, especially in this case.
Well, Jen, I mean, we're talking about this horrific
The-
parade of horribles that's going to happen.
Well, that's-
And what I'm suggesting is that it's not completely one-sided. Some, right? So.
Judge Stein, nothing is completely one-sided except for this contract, which is completely one-sided in my opinion. And I'm going to press to the court that the breach is based on the landlord's failure to do what he did. Then my client is out of business. And we have nowhere to go, literally, because again, you can't revive it. We can't get an injunction, we can't avoid a technical breach, we can't direct the landlord to fix the things that he's contracted to do, because we can't get into court to do it. And the most important thing, if there's really going to be litigation over a lease, don't we want to have discovery of the issues and adjudicate the issues? As I said before, if there was a AAA provision in this lease that sent us to arbitration, we would not be standing here today.
I have one more question. Why would it be in the owner's interest to serve a notice to cure, right, and then sit on it for 5 years, 6 years, a year, whatever? Isn't the landlord signaling that they want you to do something or get out? So this limbo, I don't understand. I mean, it seems to me that the limbo, that the worst limbo is what you're in right now, which is caused by all these stays and litigation and everything, which is exactly what the lease was designed to avoid. So
Except it
so
didn't
why
give us any
why would a
choice.
landlord do that? Why?
Well, in this particular matter, the one, I guess the nice way of put it, the one order, the city approved it, and it should have been, it was repaired almost immediately, right after the Yellowstone was brought. And right now, as far as we know, we're in no technical breach of anything, and we want to keep our lease the way it is.
And you've been in the premises for this
We don't want to
entire
ban the
time.
premises.
Right. So I don't understand why.
Well, there's the unspoken fact here that this is in Williamsburg, New York. That's where this is situated.
But my point
the
is
pla-
that the landlord, if you're suggesting that he wants to get in a more lucrative lease, why would the landlord sit on it and
Well, I'm not-
leave the tenant in
We're
limbo?
not saying the landlord's sitting on it. We
Okay.
have 7 actions going. This is just the
Thank you,
first of
counsel.
those.
Thank you.
Thank you.
Thank you.